2322 State of Missouri et al. We're here for the motion for judgment on the pleadings, and on behalf of the state we have Okay, welcome. And on behalf of the petitioners?
Good morning, Your Honor. Denise Lieberman on behalf of the petitioners. I'm joined here today by Mix Campbell with the National Women's Law Center, Ms. Callie Jocelyn, and Michelle Henry with Americans United for Separation of Church and State. My law clerk, Miranda Drakes, a law student at Washington University School of Law. I also want to note for the record that several of the petitioners in this case are present in the courtroom. Reverend Cindy Baum, Reverend Molly Hodge-Gordon, Reverend Krista Taves, Reverend Jan Barnes, as are students from a course I teach called Politics of Reproduction at Washington University.
Great. Welcome to everybody. Thank you for being here. And who's going to be arguing on behalf of petitioners?
On behalf of the petitioners, Your Honor, Mix Bell will, first Ms. Jocelyn will discuss the legal standard for the Missouri Establishment Clause claims and how that standard is met here in this case. Following that, Mix Bell will then discuss the state respondents' remaining arguments on Missouri's history of abortion regulations, the issue of whether conception is religious, as it appears in the Missouri law, and the lawmakers' First Amendment rights.
Okay, great. I just want to make sure I have those names ready. Correct. Is it Miss Jocelyn?
Yes.
Okay. And Miss Bell?
Mix Bell.
Mix Bell.
Yes, Your Honor.
How do you spell that?
MX.
MX Bell.
Yes.
Oh, okay, great. I'm a visual guy, so it's hard for me to sometimes auditory.
And for the record, Your Honor, petitioners also want to make sure that we make a request for a copy of the transcript from this hearing.
I'm sure Chris will be more than happy to do that for you. So, yeah. So, Ms. Lanahan, are you taking the helm here?
Thank you, Your Honor.
You may proceed.
Maria Lanahan on behalf of the state defendants. Missouri has had abortion regulations on the books for 198 years. These abortion regulations coexisted with Missouri's religious constitutional protections in Article 1, Sections 5 through 7 for nearly 150 years. An abortion regulation has never been found to violate Missouri's Article 1, Sections 5 through 7. Now petitioners ask this court to find for the very first time that similar abortion regulations somehow violate Missouri's establishment and free exercise clauses. These abortion regulations are three. The medical abortion regulations, which require abortion clinics to provide 24/7 medical support for women they prescribe abortion pills to. The no elective abortion law, which prohibits abortions except in cases of medical emergency. And the concurrent original jurisdiction provision, which allows the Missouri Attorney General to enforce the state's abortion laws. Petitioners want this court to believe that these three provisions are an establishment of religion, they support a system of worship, and they discriminate against the petitioner's creed of religion. Petitioners also make up their own test for deciding if this has occurred. They call it the purpose or effects test, and that test has no basis in Missouri constitutional law. In Missouri, the test for whether a statute violates the Constitution is the plain meaning of the Constitution and the plain meaning of the statute, and it's as they have been historically understood. Missouri courts do not look at statements of individual legislators because of what one legislator says cannot be imputed to another. And because this court is considering the constitutionality of a statute, this court gives the benefit of the doubt to the statute's validity. This means that if there are two ways to interpret the statute or the Constitution, one of which causes the statute to violate the Constitution and the other which doesn't, then this court picks the interpretation that results in the statute surviving constitutional scrutiny. Because petitioners have not shown that the challenge provisions clearly and unequivocally violate the Missouri Constitution, this court should grant judgment on the pleadings on all counts and all challenge provisions. I'd like to talk about Article 1, Section 6 first. Article 1, Section 6, the part petitioners point to, is that no person can be compelled to support any system of worship. The alleged facts in the amended complaint do not show that petitioners are being compelled to support any system of worship. What is the system of worship that they are being compelled to support? Additionally, the word compel indicates that petitioners are being forced to act in some way. But there's no allegation they're being forced to act here. The most they can say is they're being prohibited from acting. No Missouri case has ever found that a health and welfare regulation violates Article 1, Section 6, and this court should grant judgment on the pleadings on Article 1, Section 6 with respect to all three remaining challenge provisions. Now, they talk about a couple of ancillary circumstances around the passage of the bills that they say somehow compel a person to support a system of worship. So when we talk about this subject, we sometimes have to break up the remaining challenge provisions into the bills they were passed in. So two of them were passed in SB 5 in 2017. That's the medical abortion regulations and the concurrent jurisdiction regulation. And then there's the 2019 bill, which is 126, HB 126, and that's the no elective abortion law. So sometimes we're going to split those up. Petitioner's first complaint is that some of the legislators made allegedly religious comments about both bills. But their brief actually seems to run away from that argument. They say that legislators can vote for a bill for any number of reasons. Now, obviously, that's true. We don't know why all the legislators voted for a bill. And we don't even know that a legislator who made a speech about a bill voted for the bill for the same reasons as he said in the speech. Petitioners are right to run away from the argument about legislator comments because it has no merit. It doesn't matter. Under Ocello, case in this state, and a host of other Missouri cases, courts do not impute statements by one legislator to the entire General Assembly. Because as petitioners themselves admit, everyone has different reasons for passing a bill. Ocello calls this guesswork. We don't do guesswork when we're trying to decide whether a statute is constitutional. But even if legislator speeches could be relevant, they wouldn't matter here. The bills passed by far more than the number of legislators that were making the complaint of comments. And the comments don't show that the legislators wanted to impose their religion on others, only that the legislation was in harmony with those legislators' religions. There's no functional difference between the type of religious comments made during these two bills and the passage of the Civil Rights Act of 1964, and they admit that in their brief. Simply put, legislators can vote for bills for religious reasons, and they can give religious speeches about those bills without violating the Constitution. Imagine, though, if the opposite were true. Imagine that atheist legislators are allowed to talk about the ethics of the bills because they do not believe in God. But legislators of faith cannot talk about the ethics of bills because their morality is grounded in religion. This runs afoul of the federal free speech clause and the federal free exercise clause because it discriminates based on religion and religious speech. The legislators' speeches do not change the constitutionality of the remaining challenge provisions. This would also cause Article 1, Section 6 to run afoul of Article 1, Section 5. That states that no person shall, on account of his or her religious persuasion or belief, be rendered ineligible to any public office of this state. If you take legislators who are religious and say you can't vote for bills because they agree with you and your religion, then you're basically excluding them from office. Along similar lines, petitioners claim that two representatives were asked why SB 5 was necessary to protect health and safety. And those two representatives pointed to an investigative report from the Senate Committee on the Sanctity of Life. This argument cannot apply to HB 126 because it's about SB 5, so it doesn't apply to the no elective abortion law. This argument's also problematic because it makes several unfounded logical leaps based on the name of the committee only. that the committee must be making religious findings because sanctity must be a religious word, even though it also means inviolable, by the way. And that because 2 legislators relied on those findings, everyone else must have, and the bill must be religious. These assumptions directly contradict Missouri law. They're guesswork. It suggests that Missouri law suggests that legislation has to be given the benefit of the doubt. Finally, the third complaint is that 2 other statutory sections that are not challenged in this lawsuit contain allegedly religious language. So let's talk about those languages. Chapter 188 is where those 2 provisions fall. 188.010 references that Almighty God is the creator of life. This is not that different from what the Missouri Constitution's preamble says and the Declaration of Independence says. Then there's section 188.026. It references that at conception, a new genetically distinct human being is formed. That's a statement that's been adopted under numerous Missouri cases, including Robinson, as well as other cases in other states. So first, what 010 and 026 say cannot be imputed to the medical abortion regs or the concurrent original jurisdiction provision because section 188.010 and 026 were not passed until 2 years later. Second, courts cannot impute one section's language to any other section under Doe v. Parson, especially when the section with the complaint of language is not even being challenged. So here, those 2 sections aren't being challenged. Third, let's look back at the language of Article 1, Section 6. Big picture here. Even if any of this is true, even if some of these comments were religious and maybe that matters, look back at the text. That no person can be compelled to support any system of worship. Doesn't matter what the legislators say. No one's being compelled to support a system of worship. In short, the ancillary circumstances that petitioners point to do not change the challenge provisions into violations of Article 1, Section 6. So this court should grant judgment on the pleadings on that count. Then there's Article 1, Section 7. This one says, and petitioners point to, no preference shall be given to, nor any discrimination made against, any creed of religion or any form of religious faith. Petitioners claim that the 3 remaining challenge provisions create a preference for or discriminate against their creed of religious faith. But in their motion to dismiss and motion for judgment on the pleadings papers, petitioners make clear they are not bringing a free exercise claim, only an establishment clause claim. That's a problem for them because the text they identify here in Section 7 of Article 1 of the Missouri Constitution, that's free exercise language. So they're trying to shoehorn an establishment clause claim into a free exercise provision. And there's good reason why they're trying to do that. They're trying to avoid some of the law that goes with free exercise claims. So there are exceptions that apply, that don't apply in establishment clause cases. So because they have basically argued that they are not bringing a free exercise claim, this court should grant judgment on the pleadings on Section 7 on this basis alone. But even if it doesn't, the free exercise claim fails because the alleged facts, because they do not meet either of the 2 required elements for free exercise violation. So those 2 elements are these: the law not be neutral and generally applicable, and that the law not satisfy strict scrutiny. The challenge provisions are neutral and generally applicable here. No religious group or person is being treated better or worse than anyone else because of their religion. The challenge provisions apply equally to everyone. Catholics, Jews, petitioners, atheists are all treated the same. No one can provide an abortion except for in medical emergencies. Abortion clinics must provide 24/7 support to women when they give out abortion pills to them. And the Attorney General can enforce the Missouri abortion statutes. This case is not like other free exercise cases where there was a free exercise violation found. Take Lukumi, U.S. Supreme Court case. Rules on animal slaughter applied to religious beliefs and sacrifice of animals. but they did not apply to hunters, and they did not apply to restaurants. That's not neutral and generally applicable. Consider Newsom or the Cuomo cases. These are COVID cases where the government put more COVID restrictions on religion than on business. Not neutral and generally applicable. This case isn't like either of those. The remaining challenge provisions apply equally to everyone. Because they're neutral and generally applicable, we don't need to get into the strict scrutiny test. We do explain in our brief why they are supported by compelling state interests and why they're narrowly tailored to those interests. But we don't need to talk about those necessarily here. And for similar to Article 1, Section 6, the circumstances of the bill's passage do not change, whether the bill violates Article 1, Section 7. This is true for the reasons we already talked about in Article 1, Section 6, but it's also true because free exercise and equal protection, under those types of claims, the way that the court looks at legislative purpose is very different. It's actually through the strict scrutiny test. What it does is it takes the compelling interest and it measures it against what the law actually does in practice, the narrow tailoring of it. If the law is too broad or too narrow to satisfy the compelling interest, then the law can violate strict scrutiny. And that's how the court gets at this legislative purpose piece. But again, we don't have to reach strict scrutiny because the laws are neutral and generally applicable here. And finally, even if courts could look at legislative statements, those statements do not show that any of the challenged provisions were passed to discriminate against any creed or form of religious faith, rather than to protect the life of both the mother and the child. And from a historical perspective, petitioners cite no case where a health and safety regulation like these ones violated Article 1, Section 7. This court should grant judgment on the pleadings on Article 1, Section 7 claims. Last, we have Article 1, Section 5. I want to break this up into two parts, pre and post 2012. So pre-2012, in 2012 there was an amendment to the statute. So I want to talk about all the language that was included in pre-2012, and then talk about all the language that was added after. So, pre-2012, it's pretty clear that the abortion regulations do not violate the parts of Article 1, Section 5 that existed pre-2012. Article 1, Section 5's right of conscience, it says no human authority can control or interfere with the rights of conscience. But this is tempered by another part of the same provision. It says this section shall not be construed to excuse acts of licentiousness, nor to justify practices inconsistent with the good order, peace, or safety of the state or with the rights of others. So it's pretty clear here that challenge provisions easily fit within this exception. If they didn't, this wasn't about good order, safety, the rights of others, then the state couldn't pass murder laws. Historically, abortion statutes have also coexisted with this part of Article 1, Section 5 for more than 100 years. And petitioners cite to no health or welfare regulation that has ever violated Article 1, Section 5. Like for Article 1, Section 6 and 7, the circumstantial evidence around the bill passage does not change the analysis for the same reasons. So now we want to talk post-2012. There were some amendments made to the the Constitution, one of which says that basically that the state, neither the state nor any of its political subdivisions shall establish any official religion. So the Establishment Clause language in the post-2012 statute is similar to, but a little bit narrower than the federal Establishment Clause language. So Missouri courts typically will bring over the federal language when that's the case and use the federal test. It's a little bit narrower here in Missouri because it says that you can't establish an official religion. There's no official language in the federal Constitution. But essentially, if the challenge provisions do not violate the federal Establishment Clause, they don't violate the Missouri one. So, first off, Rogers v. Danforth, 1972 case, held that a similar statute did not violate the Establishment Clause. It was an abortion statute. It did not distinguish, that case did not actually distinguish between the federal and state establishment clauses, and it didn't cite any federal Establishment Clause case law. So Rogers is controlling here. Certainly the petitioners have not shown that it's not controlling. But even if this court wants to distinguish Rogers, There are plenty of federal and state cases showing that laws with any secular purpose survive. For instance, laws relating to murder, theft, adultery, abortion, polygamy, and Sunday closing laws, they don't violate the Establishment Clause, even under the old version of the federal test. For instance, and then the old version of the federal test, by the way, is harder to satisfy than the new one under Kennedy v. Bremerton. So, for instance, the no elective abortion law is much like a murder law with a self-defense exception. And that is a law that's referenced in McGowan, and it clearly does not violate the Establishment Clause. So, and even laws with clear religious motivations that are hinted at their text. Here, in our case, none of the textual provisions of the law that are challenged here, none of them have religious language in them. But there are cases addressing Sunday closing laws where there is religious language in the text. So the statute saying things like basically trying to preserve the Sabbath day, exempting mourning activities on Sundays, forbidding profaning the Lord's Day, those types of things, and prohibiting activities within 100 yards of a church or a religious service. Those kinds of laws have survived under the Establishment Clause because they have a secular purpose as well, a day of rest. This case is not anything like those. We don't have any language in the statutes that are being challenged like that. But still, even if there was, it would be satisfied, and this Establishment Clause would not be violated. The new version of the Establishment Clause test was actually addressed in Kennedy v. Bremerton. That's what applies today. It's easier, and it's that courts look at whether provisions like the one at issue are historically understood to be Establishment Clause violations. Here, the abortion regulations are nearly as old as the state. They have never violated the U.S. Establishment Clause. They've never violated Article 1, Section 5, and they don't now. This court should grant judgment on the pleadings on Article 1, Section 5, as well as the other counts. There is just no Missouri case suggesting that the challenge provisions violate the Missouri Constitution. What petitioners are doing in this case is repackaging a long discredited theory that was rejected by the U.S. Supreme Court 6 decades ago. And there's a good reason to reject it. It leads to anarchy. Not only is their argument illogical, but none of the text supports it. The whole factual premise for what petitioners are trying to argue is entirely implausible. They're trying to say that the only reason a person can be pro-life is because they're religious. That's obviously not true. Religious people can be both pro-life and pro-choice, and that's also true of non-religious people. Petitioners have ignored the authority we've cited to the contrary, such as the March for Life cases. This court should grant judgment on the pleadings on all counts.
Thank you, Ms. Lanahan. You'll have a chance to reply after petitioners respond. So, Ms. Jocelyn, are you going first, I presume?
Good morning, Your Honor, and may it please the Court. My name is Callie Jocelyn, and my half of this argument will clarify the proper legal standard for challenges under Missouri's Establishment Clauses. As we stated earlier this year, a law clearly violates Missouri's 3 Establishment Clauses if it has the purpose or effect of imposing religious beliefs as law. The challenged provisions do both. At this stage, petitioners' well-pleaded facts are treated as true, and petitioners are accorded all reasonable inferences drawn therefrom. I'll say a bit about the test itself, then discuss the challenged provision's religious purpose and preferential and coercive effects. The state respondents say there is no test other than the text, but that's simply not true. When the Missouri Supreme Court stated that Missouri's Establishment Clauses are distinct from and more protective than the Federal Establishment Clause, the Federal Establishment Clause was interpreted to ask whether the law has a religious purpose or effect. The Missouri Supreme Court has applied this analysis to interpret Missouri's Establishment Clauses at least twice before. in the Americans United case and the Menorah case. In Menorah, the court specifically said this test has been recognized by Missouri courts. It's also been applied by the Missouri Court of Appeals in the Boone case and the 8th Circuit in the Clayton case, interpreting Missouri's establishment clauses. As the case law consistently shows, Missouri's establishment clauses are interpreted holistically rather than piecemeal to protect against the establishment of religion. As a result, everything that was an unconstitutional establishment under the federal purpose or effect standard likewise violates Missouri's establishment clauses, and some governmental acts that wouldn't violate the federal clause still violate the state clause. If the Missouri Supreme Court wanted Missouri's establishment clauses to be coextensive with the federal clause, it would have said so, just as it did in the equal protection context in the Glossop case. Turning to the law's religious purpose, if a law's predominant purpose is to impose religious beliefs, that is clearly unconstitutional. This is why it would be unconstitutional for the state to adopt the Bible as its official state book. And this is true even where religious beliefs are shared by more than one religion. Missouri courts are required to look at the entire context of alleged establishment clause violations, which in the context of an unconstitutional law includes the context of that law's passage. Here, the context shows that the purpose of both SB 5 in 2017 and HB 126 in 2019 was undeniably religious. But the state respondents say, ignore context, look only to the law's text and stated goal to see if it advances any plausible secular purpose. That can't possibly be the rule. The U.S. Supreme Court has repeatedly rejected that approach for the less protective federal clause. In McCreary County, the U.S. Supreme Court said that the legislator's stated secular goal, quote, has to be genuine, not a sham, and not merely secondary to a religious objective. And in Santa Fe, the U.S. Supreme Court said it's court's duty to distinguish a sham secular purpose from a sincere one. Despite the state respondents' contention, these cases weren't overruled by Kennedy. Ignoring petitioners' allegations of pretext and deferring to the stated goal would make the federal establishment clause more protective than Missouri's establishment clauses, rather than the other way around, and it would lead to absurd results. For example, the state could make the Bible the state book as long as it said the stated goal was to promote literacy and civic engagement. To give another example, the state could pass a law requiring delis to stay open on Saturdays, which on its face isn't religious, it just seems like an economic regulation, but the state says that law would be constitutional even if there was evidence in the record that the law was passed due to anti-Semitism and discrimination against Jewish delis that close on Saturday to observe the Sabbath, and even if the law said in the statute itself that Sunday is the true Sabbath, the state would say that's okay because we're looking to the law's stated goal and the text itself. The claimed purpose of SB 5 was to promote health and welfare, but that was pretext for the law's primarily religious purpose, as shown in part by the legislature's reliance on the Sanctity of Life Committee report. The state respondents say sanctity also has a non-religious definition, inviolability, but that conveniently omits the rest of the definition that appears on Webster's online website right before inviolability. Quote, the quality of being holy or sacred. State respondents say denying the motion for judgment on the pleadings would break new ground in Missouri law, but at this stage, factual allegations of pretext are treated as true. And HB 126 even states its religious purpose on its face. Section 188.010 said it's the intention of the General Assembly to regulate abortion in recognition that Almighty God is the author of life. In Section 188.026, which the state points to for the justifications for the total abortion ban, contains no less than 9 references to conception. We don't challenge these provisions themselves because they're statements of intent. They don't do anything on their own, so there would be standing or ripeness challenges if we were to challenge them directly. But they do show the intent of the total abortion ban, which we do challenge. The challenge provisions also have 2 unconstitutional effects. The first is preference. Article 1, Section 7 plainly prohibits governmental preference to or discrimination against religious beliefs. This is another reason the state can't pass a law making the Bible the official state book. The state respondents say in their briefs that the U.S. Supreme Court held all of Section 7 unconstitutional in Trinity Lutheran, which it simply did not do. That case involved the competing free exercise rights of individuals, which aren't at issue here, and the U.S. Supreme Court held a Missouri policy unconstitutional, not Article 1, Section 7 itself. Here, the challenged provisions give preference in law to certain religious beliefs on abortion and the beginning of human life, to the detriment of those who don't share those beliefs. This isn't a free exercise claim, it's a straightforward Establishment Clause claim. To go back to the deli analogy, state respondents say that a law doesn't give preference if everyone is treated equally under the law. So under that logic, it would be okay to require all delis to stay open on Saturday, even specifically ignoring the targeted impact on Jewish delis and the preference that would give to non-Jewish delis. Senator Nasheed said in opposing HB 126, quote, "People can practice their religions as they see fit, but don't come legislating your own religious beliefs onto other people. That's not right." And in addition to preference, the challenged provisions are also unconstitutionally coercive. Article 1, Section 5 forbids the state from coercing people to participate in religious activity, and Section 6 ensures that no one can be compelled to erect, support, or attend any system of worship. Support means many things, not just financial support, and system of worship includes a set of religious beliefs. In the Oliver case, the Missouri Supreme Court said that state actions that merely intersect with religion aren't coercive if they don't impose requirements or exhortations to specific beliefs, or if they at least offer non-religious alternatives. But the challenged provisions failed both of these escape valves. For Petitioner Gordon, the total ban, which would require her to either remain pregnant against her will or flee the state, directly threatens her life and her health. All the challenged provisions require Missourians of various faiths, including all petitioners, to support with their taxpayer dollars enforcement of others' religious beliefs about abortion and the beginning of human life. And the challenged provisions offer no accommodation or alternative, meaning that Missourians are compelled to support the state's preferred religious beliefs at the expense of their own religious freedom, bodily autonomy, health, economic security, and equality. It's difficult to imagine what could be more coercive. The Missouri Supreme Court warned in the Americans United case that courts should not shy away from finding the wall separating church and state. Here, the amended petition shows that wall has clearly been breached. If Your Honor has no further questions for me, I will defer to my colleague Mick Spell to address the state respondents' remaining arguments.
Okay, I don't have any questions. Thank you.
Thank you.
Good morning, Your Honor.
Morning.
May it please the court. My name is Nick Spell, and I will be continuing by addressing some of the state's arguments that they raised today. This court is, the provisions that were challenged in this case, Your Honor, were passed in 2019 and 2017. And the appropriate law to look at in evaluating those provisions is the constitutional language and the case law that is in effect now, not the law as it stood in the 1800s. The state respondents at one point in their brief suggest that this court shouldn't look at case law from 1945 because the Supreme Court was making a problematic decision, and they specifically cite Korematsu, but they want this court to look back to the 1800s, about a century before women could vote, and when the original abortion ban in the state was passed, when slavery still existed. In addition, Your Honor, the understanding of the Establishment Clauses has changed significantly since then, as additional cases have been decided in the Missouri Supreme Court. For example, if you look at the Hannibal case, which was decided in 1852, 15 MO 634, in that case, Your Honor, the Missouri Supreme Court found that church purposes were public purposes, and it was okay to favor the Christian religion. That is not the understanding of the establishment clauses in Missouri that when these bans were passed in 2019. In addition, Your Honor, as my colleague has already set forth in detail, the test requires the court to look at the purpose of the laws, which includes looking at the surrounding circumstances now or the time that those laws were passed.
I was a little confused on this in reading your response. Does that have to be a purpose or the predominant purpose?
Your Honor, we would argue that that a purpose to establish religion by the state is sufficient to overturn the statute, but regardless of whether it is a purpose or a predominant purpose, that standard is clearly met here for several reasons. One of those reasons is the language of the statutes themselves. The 2019 statute specifically states, in recognition that Almighty God is the author of life. So it is not simply a passing reference to God, but it is actually stating that because of a religious belief that God is creating life, that abortion should be banned in the state. And so we know that this had a religious purpose because when the lawmakers passed the ban in 2019, they told us that. There is also language, Your Honor, that says that the fact that the life of an individual human being begins at conception. That is in the 2019 statute. And as used here, that is a religious belief. Because different, as we pointed out in our petition, different religious groups have different beliefs about when life begins. And the term conception is a religious term that existed before science even knew what fertilization was. And it was believed that male and female and God all came together to create a new life. Obviously, the science has advanced considerably since then, and sometimes today, Your Honor, the word conception is conflated with fertilization, or sometimes it's conflated with pregnancy, which actually does not occur at the time of fertilization, but later when the embryo implants in the body. And in addition to the language of the statute itself, Your Honor, there is other evidence as well. My colleague brought up the statements of lawmakers, and in fact, the courts can consider other circumstances. One of the cases cited by the state, and I apologize in advance for my pronunciation, but the Couer case, the court discussed the difference between the motives of a single legislature and the purpose of the law. And a number of the cases cited by the state respondents were about zoning cases where there was an allegation that one of the city council members of the local legislators had some sort of financial interest in maybe their property value, something like that, in the zoning rule. And the court said, well, we're not going to go behind the legislation and look at possibly an improper motive of one legislator. We don't think that's appropriate for the courts. And the courts noted that some legislators have conflicts of interest rules and things like that that they use to address these issues. But the court did say that the courts can look at the purpose of the law. And so we are using the statements of the lawmakers as evidence of that purpose. And in the case of Community Bank of Kansas City versus Missouri Division of Finance, 762 SW2D 431 in 1988, the appellate court of Missouri just said that while the statements of the representatives concerning the intention of the statute, while those can be entitled to some weight where they're consistent with the statute and other legislative history, those statements are not controlling. But the court can look at those statements in evaluating the purpose of the legislation, which is ultimately the determination that the court needs to make. Now, the state respondents are correct that there can be different motives for supporting a statute, and that, Your Honor, is why the lawmakers' individual rights are not implicated here. We certainly do not disagree that individual lawmakers have free speech rights, and they have free exercise rights. But their act of voting is not their act as individuals. As the Supreme Court made clear in Kerrigan, they are exercising their apportioned share of the legislator's power. That's why the act of voting is not speech. And all of the protections in the First Amendment for free exercise and free speech, those are there to protect individuals from the power of government. They don't protect the government. They don't protect the government from itself. And so when lawmakers pass legislation, they are acting as the government in doing so, not as individuals. Certainly their speech when they're trying to get elected, things like that, they're acting as individuals there, but they're taking government action when they pass a law. And in fact, in the Muslim ban case, in the recent case in the Supreme Court, the Trump case that we cited in our pleadings, the Supreme Court not only looked at the statements of President Trump, but they looked at his campaign statements even in evaluating whether or not the action by the president in excluding people from certain countries to the U.S. was a violation of the Establishment Clause. So in both Missouri law and federal law, there is ample precedent for this court looking at what the lawmakers said that they were doing, both in the statute and on the record. As far as the Rogers versus Danforth case, we set forth 3 reasons in our brief why that is not binding on this court. Perhaps the most important of those is that the case was based on a factual stipulation, which not only did petitioners here not stipulate to, but with which we strenuously disagree. And so because of that, the issues raised in this case are not raised here, and without that stipulation, the finding in that case is not applicable.
And that stipulation was that conception is when life begins, is that right? Or
it is
something like that?
Similar, Your Honor, but not identical.
Okay.
It is set forth in a more scientific type language, but it says that all other unborn children, which of course we would argue states a position there, as opposed to a fetus or an embryo, have all the qualities and attributes of adult human persons differing only in age or maturity. We would strongly disagree as a scientific matter that that is correct, since an embryo does not have organs, for one thing. But the stipulation, there was no grappling with this statement, life begins at conception. The court did not have occasion to consider whether that was religious. And in addition, Your Honor, the entire holding, the analysis of the federal establishment clause challenge there was very brief. But in the approximately 3 sentences that the Missouri Supreme Court conducted its analysis, relied entirely on the Furman versus Georgia case, which of course was overruled 4 years later in Gregg. In addition, Your Honor, the circumstances of that case were different in terms of the surrounding circumstances of the ban, the sort of scientific and medical understanding of pregnancy. All of those things were different than they were when the challenge provisions were passed. Again, Your Honor, in determining the purpose of the statute, we would urge the court to look at the statements that the lawmakers made, and at this point, Your Honor, this is very early in the proceedings, and of course the court is aware the standard is that any sort of factual disagreement must be taken in favor of the petitioners. So we did not set forth a lot of scientific information about about fertilization and how conception is being used at this stage in the proceedings, because we have pled enough with the language of the statute. Oh, and
let me ask you a little bit about the standard here, because we already had the motion to dismiss, which I think was largely, from my perspective, focused on standing issues. I know there were some other things at the end that I don't think were fully briefed and developed at that time. But of course, on a motion to dismiss, we take all the facts as true. On a motion for judgment on the pleadings, we take the well-pleaded facts as true. Is there a difference there, and how does that affect this, if at all?
I think that there's little difference. At this point, we have pled, again, pointing to the language of the statute itself, the reference to Almighty God, which again, the state points out that, there's references to God elsewhere in the Constitution, but those are not operative. Whereas here, the reference to God as the author of life is the basis for the ban, which then binds everyone. So this is a different scenario from simply a passing reference that does not have an operative effect. And we also pled the statements of the lawmakers. I don't believe that there's a factual dispute about what was said, but certainly if there was, those factual disputes would go towards us at this stage, Your Honor. We also argue that the use of life begins at conception as a religious idea is, potentially a factual question in terms of how it's being used in the law. And we believe we pled, again, with the surrounding statements as well as the language of the statute enough to demonstrate that. I mean, ultimately, this court will be determining what the purpose of the statute is. And clearly there's a dispute as to what evidence this court should look at in determining purpose. I do agree with Your Honor that the standard here is similar, but we would argue that we have pled more than enough to meet that, given that the legislature itself told us that this bill was being passed for religious reasons. And, to give another example, in addition to the example that my colleague gave about the deli, and the reason being animus versus public health, if the legislature got together and said, there's been an increase in thefts in Missouri, we're concerned about it, we're going to bring back corporal punishment, and they passed that as a law. If the legislature was doing that because they thought that that would be a deterrent to people, there might be a debate about whether that was constitutional, and presumably some people would come in and say corporal punishment existed at the founding, and other people would come in and say Eighth Amendment evolving standard of decency, you can't do this anymore, and the court would decide whether or not that was constitutional. But if the legislature said, we're passing this law because as Christians looking at the Old Testament and Muslims looking at the Quran, they had corporal punishment for theft, and so therefore we think that's what the policy of the state of Missouri should be, that would not be constitutional because the purpose of that law would be the establishment of a religious belief to bind everyone. And that is what the legislature is doing here with this ban that binds everyone, including our petitioners who do not share the religious belief that Almighty God is the author of life and life begins at conception, and therefore no abortion should be allowed.
Okay.
I just want to say one other thing about this idea that the legislators have personal rights potentially to violate the Constitution. That is not and has never been the law, and in fact, if that were the law, if the lawmakers had a free exercise right to pass unconstitutional laws, there would be no more Establishment Clause. If a school teacher said, well, I have a free exercise right to proselytize during class because the co-teacher talks about their secular views, which is a classic Establishment Clause violation, then if that was free exercise, then there would be no Establishment Clause. Similarly, with the free speech rights, if that would also lead to absurd results. I mean, It would insulate Your Honor's opinions from judicial review because you have a First Amendment right to your beliefs or to your views. Obviously, that's not the case. The Supreme Court of Missouri can review this court's opinions because when you issue an opinion, it's government action. It's not you expressing your right to free speech. And so if Your Honor has no further questions.
I don't think I have any questions. I do, but I don't think I can formulate it, so I think I'm okay for now.
Thank you, Your Honor.
Thanks.
So I just want to address a couple of things, big picture wise. Purpose or effect test. So in the motion to dismiss hearing, we were discussing the purpose and effect test. And they were using it. I got up and said, I'm a little confused. I've never seen this in Missouri law. And when they got back up and talked, they said, it's not. And that's the problem, actually. There's not a Missouri test. And so this is the test we think applies in Missouri. If you look back at the transcript, I think that will make things a little more clear. The cases they cite to for this test address Federal Establishment Clause claims under the U.S. First Amendment. And I think it's pretty clear that the ones that they cite to do that, or they're certainly just referencing the Federal Establishment Clause. They're not applying that test to the Missouri, Article 1, Sections 5 through 7. And then I would also caution this court to take a closer look at each one of those cases, because not all of them are addressing every single Missouri constitutional provision. Some are addressing only Section 5, or only Section 7, or Section 7 and 5, and not Section 6. So, I think it's basically to just lump all this together and say, oh yes, the Missouri test is purpose and effects for all of Article 1, Sections 5 through 7 just isn't the case. So even if this court disagrees with us and thinks that basically the Missouri Constitution had applied the federal purpose and effects test to the Missouri Constitution, which isn't true, but let's say that it did, that test changed. So we pointed out in our brief that when the Missouri Supreme Court is applying a federal test to a Missouri portion of law because it's the same basically, then that changes through the years as the federal law changes. For instance, we pointed out Lawrence v. Texas. The Missouri Supreme Court recognized that change in the law back in 2003-ish, and they referenced it in an opinion about the Missouri equal, I believe it was equal protection, but yeah, basically referenced it and said, this would apply when we have to consider whether it applies here. And so they can't just say, oh, well, the purpose and effects test applies in Missouri because it used to apply in federal law. It doesn't apply anymore in federal law. Kennedy v. Bremerton is the test, and it says, look at history. Look at history about what constituted an establishment of religion, okay? And so I think that's why we talk so much about the history here. I want to talk about this issue about the state somehow made the Bible like the official law of the state or something like that, or somehow used the Bible in a way, forcing the Bible upon people. I think there's a difference between a state law or a state action that's secular on its face and one that's not. And so I think that's the difference here, is that if you've got a law like these three that are secular on their face, they don't have a religious purpose on their face.
Doesn't one say because Almighty God is the author of life?
No, not the sections that are being challenged here.
Okay.
And that section is separate and apart from this one, and it actually does nothing. Absolutely does nothing. If that court got rid of that section, which by the way isn't even challenged as an establishment clause violation in this case, if this court got rid of that section, nothing would change. The law would be the same. And so I think that there's a huge difference there. And plus, if this court decides that it's going to strike down this provision because that Almighty God is the author of life language, I mean, the whole Missouri Constitution's gone, because that's right at the beginning of the Missouri Constitution.
Let's move away from that one and talk about the conception provisions, because is conception a religious term? Is it a scientific term? Is it a philosophical term?
I think what you would do is, because they're pointing to sort of this you would look at it in the statute and say, what is it in the statute? And I think it's definitely a science term, and you know this because of Missouri case law talking about science and conception hand in hand. And a lot of the cases we cite to, I think we cite to 2 Missouri cases and 6 other cases from other states, talking about how conception and fertilization are essentially the same thing. And even their science, one of their scientists that they cite to and incorporate by reference, Richard Paulson, admits that there is life after fertilization. So fertilization is a thing. Conception and fertilization are essentially treated as the same thing in Missouri law. And so that is where the science piece comes in. And even if this question of conception, first of all, I don't think you can say it's religious, because their own scientists admit that there are scientists out there who believe that life begins at conception. So it might be bad science, but it's science. I don't think you get to say that, oh, we're going to ask, is it possible to tell when life exists? And if your answer is no, then that's science. And if your answer is yes, and let's assuming that's correct, then that's religion. No, it's either a science question or it's a religion question. It's a science question. So I want to talk a little bit about the deli closings question, right? That's a free exercise claim. So it's not necessarily an establishment claim. It's basically saying that you're closing all delis or you're making all delis be open on Saturdays, and that somehow is violating Jewish people's right to go celebrate their religion and or do the things they need to do. That's a free exercise concern. It would go under the free exercise test, and we talked about the free exercise test earlier. And that's also why, because there are issues like this, that we have a Missouri RFRA statute, which basically gives everyone an exception from these generally neutral and generally applicable laws if they've got a religious out, basically being religious out. So, if what they say
if you did it the other way and said all the delis have to be closed on Saturday because of the Sabbath, is that an establishment clause?
No, for the same reasons that the Sunday provisions I don't think are.
Okay.
And I do think, so you got to kind of look at this also, if what petitioners say is true, and the state could not have a murder statute because some people believe that terrorism is a part of their religion and they should be murdering people, okay? That's the problem. So I don't think they get to say you can't have an abortion statute for the same reasons.
I'm going to say that I don't think anybody believes terrorism is part of their religion, that is a serious religious person.
There are some fundamentalist sects out there.
But we don't need to go down that path, perhaps.
Yes. So anyway, I want to talk about, they make this argument that we're going back, well, we can't look back to 1945, but we sure as heck can look back to the 1800s to tell whether something is an establishment. Well, here's the problem. That's the test, is the history of the bill and the history of the provisions. So that Kennedy v. Bremerton, if you're going to apply federal law, that's what it says, is look at the history. And is this an establishment as understood in Missouri law, in federal law?
Can I ask you about the differing standards between a motion to dismiss and a motion for judgment on the pleadings?
Yes.
Do you have anything to say about that?
So here the standard is that we're taking all the well-pleaded facts as true, as pleaded in their petition.
What does well pleaded mean, I guess, is my
I think anything
hang-up.
it has to be plausible, right? I mean, you can't say that, like, the sun is made of ice and believe it, but, you know, if it's well pleaded, I think, then you can accept it as true.
Okay.
But I don't think it includes things like the idea that conception has to be a religious concept, because what conception means is determined by what Missouri law says it means, right? So I think that's a legal question, not a factual question. But I think that's what this court is going to be looking at, is what's legal, what's factual, and trying to distinguish those things. And they say, well, you can only grant judgment on the pleadings if there's no factual disagreement. Well, like I said, we're accepting all the well-pleaded facts in their petition is true, and the only way there would be some sort of factual disagreement is if we were saying that we're relying on some facts that we allege in our own pleadings which we're not. So there's no factual disagreement for the purposes of this motion. And then, basically, if what they have written in their amended petition is not sufficient to give them relief under the law, then it should be not dismissed, but you should give judgment on pleadings. Wanted to just say, if what they say about religious arguments is true, then the civil right and how you cannot consider you must consider a legislator's what he talks about at the discussions about a bill, then the Civil Rights Act of 1964 is gone, basically gone, because there were people on both sides arguing religious arguments, and I think that's a real problem for their argument, and they admit that there were religious arguments being made in that bill, and so that's a problem. So I think that's what I've got. Do you have any other questions for me?
I don't think so.
Yeah, we would just ask this court to grant judgment on the pleadings.
Okay, thank you very much. I assume nothing else from you guys?
We would like to rebut.
Okay.
Hi, Your Honor. Thank you. I have 4 points I'd like to make. The first is that the state said that the Menorah case and the Americans United case weren't specifically about the Missouri Constitution, and I'd like to point to language in both of those cases that specifically says it did address the Missouri Constitution. In the Americans United case, there was both a federal and a state establishment clause challenge. The state clauses were Article 1, Section 6 and 7. The Missouri Supreme Court applied the purpose and effect or that analysis to the federal challenge. It then said the Missouri Constitution was more restrictive, and it borrowed that effect test for the state's analysis. It said, quote, "In answer to the second part of the federal test heretofore reserved, we are convinced that the statutory program does have a primary effect other than the advancement of religion." And the Menorah case did not specifically cite Article 1, Sections 5 through 7. It did not say which of Missouri's establishment clauses it was addressing, but it said in that case, quote, "Appellants contend the agreements violate church-state provisions of the Missouri Constitution," and it concluded that the state is not involved in establishing religion. When it applied the three-pronged test, it said this test has been recognized by Missouri courts. That's my first point, Your Honor. The second point, I would like to reiterate that Missouri's establishment clauses are not coextensive with the federal clause. As my colleague on the other side mentioned, in the equal protection context, it's not coextensive. As on page 32 of their reply, they quote the Glossop case, specifically saying, Missouri's equal protection clause has been interpreted to be coextensive with the federal. The Missouri Supreme Court, or no Missouri court, has said that Missouri's establishment clauses are coextensive with the federal. That's my second point, Your Honor. My third point goes to the doctrine of constitutional deference or constitutional avoidance that the state mentioned. The doctrine does not mean that if there are two interpretations of a statute, the court has to choose the constitutional one. The two cases they cite for that, the first, Johnson v. State, is about interpreting constitutional provisions, not statutes. In the second case, Lang v. Goldsworthy, simply says that courts avoid deciding constitutional questions if the case can be resolved fully without reaching it. That doctrine is not applicable here on these claims, and the court specifically can't choose the state's reading of the statute due to this doctrine on a motion for judgment on the pleadings. That's my third point. And then my fourth, I would like to talk about the Civil Rights Act and laws prohibiting murder, theft, perjury. There's a crucial difference, Your Honor, between laws that merely coincide with religious beliefs and laws that have the primary purpose for effect of imposing religion as law. In McGowan, the U.S. Supreme Court Sunday closing case, the court explicitly said a law may still violate the Federal Establishment Clause, quote, if it can be demonstrated that its purpose, evidenced either on the face of the legislation, in conjunction with its legislative history, or in its operative effect, is to use the state's coercive power to aid religion. We look to the law's present purpose and effect. I am surprised that the state said that a law saying that all delis have to close on Saturday because of the Sabbath wouldn't violate the state establishment clauses, because we are looking to the present purpose and effect. And if the present purpose and effect of that is clear, that would violate the Constitution, unlike Sunday closing laws, which the U.S. Supreme Court traced back to the 1400s and said have lost their religious nature over time. I believe that's all I have to know.
Okay, thank you, Ms. Jocelyn. I will give you the last word since it's your motion.
Thank you, Your Honor. I just wanted to note this Americans United Purpose or Effect test. I don't think that that's what it says, that this is like this is a Missouri test, but to the extent it references purpose or effect and then kind of talks about that, it's really referencing it in kind of terms of public aid for religious purposes, and it doesn't address anything outside of that. So Article 1, Section 6 and 7 have to do with paying money to religious organizations, and so I think that's kind of what they were looking at there. This case isn't at all about that, so I think it can be distinguished on that basis as well.
Okay, thank you everybody for your arguments. As usual, you've done an excellent job in your briefing and your arguments to make my job really difficult. But I will try to get you an order out that properly addresses and makes a decision on the issues in this case. And I will give you a little bit of a preview that is probably not going to be before the first of the year, because the end of the year is very busy around here finishing up all the other things I have under submission, and this is going to require a little bit of time because there's a lot of surrounding case law, as you've noted in your briefing and stuff. So I'll do my best to get to it as soon as possible, but I would look to January if you're thinking when it might come out. So thank you again. Thank you everyone for being here, and have a nice Thanksgiving, everyone.